Today we're talking about weed, cannabis, marijuana, pot, hemp, the devil's lettuce, whatever you want to call it. You know what I'm talking about. Either you use it or you certainly know somebody who does or has used it in the past. The question is, what does the law say about the substance? Let's have a chat about it. How's it, everyone? Welcome back to Sed in Arbiter. My name is Gil, and on this channel we talk about South African law. I try to simplify it as much as I possibly can, and I hope that you can walk away from this video having learned something. I also want you to use your fundamental human rights of the right to dignity and the right to freedom of expression to go ahead and like it if you like this video, dislike it if you dislike it, comment if you have something to say, share if you can, and subscribe if you're cool. Now, marijuana plays quite an important role in a lot of people's lives, and to some people it forms part of their identity. And there is a lot of confusion about what the status of marijuana is in this country. A lot of people are aware of the September 2018 Constitutional Court case where they would say that they decriminalized marijuana, but it was only to a certain extent. I was there that day on Constitutional Hill, and I must tell you, it was a momentous day. It was magical. You could smell marijuana from the streets outside the court. People were lighting up, blunts right in front of the Constitutional Court. And as much as that's an offense, it forms part of the bigger issue that there are a lot of people that misunderstand what the judgment actually means. And that's what I aim to clear up. So you're going to learn three things today. You're going to learn what can and what can't you do with marijuana. Basically, what is the legal status of weed in this country? Number two, you're going to learn about the first time this was ever brought to the Constitutional Court. That was way back in 2001, and that case actually ended up failing. It was rejected. And you're going to learn why that happened. And then lastly, you're going to learn about the 2018 case, the case I was talking about, and why that one succeeded and in what way did it succeed. So I'm going to call the first Prince case, the first 2001 case, the Prince case, and the 2018 case, the Prince 2 case. Mainly because Mr. Gareth Prince was a party in both of those cases, and it's what everyone knows it as. So the story of the first Prince case in 2001 starts off with a man named Mr. Gareth Prince, who is a Rastafarian, and as you may know, that's more than just a social movement. It is in fact a religion. And Mr. Prince is also an aspiring attorney. He qualifies academically. He has completed his community service hours, and he wants to register as an attorney. The issue he faces is that he has two previous convictions on possession of cannabis on account of him being Rastafarian. He also says to the court that he is not prepared to ever stop smoking marijuana because it's such an integral part of his religion. And in doing so, he's basically saying that, as far as the Law Society are concerned, that he's not fit and proper, and they can't register him as an attorney. So he brings this to the Constitutional Court, and he basically he bases the contention on the right to religion, on his Rastafarianism. And importantly, he's not asking for a general decriminalization of the substance. He's only asking it to apply narrowly and only to Rastafarians. Essentially, he asks for an exemption. He admits, and the court also says, that there is a legitimate government purpose. And I know there's some people that say that weed has no harmful effects, this and the other, but I am not getting into that. What the issue is that the court comes to is that yes, there is some harmful effects of marijuana, and that there is a legitimate government purpose to criminalize it or regulate it in some sort of way, and that, they need to get this. There is a reason why we have this criminalization of marijuana. That's as far as the law is concerned. And Mr. Prince says, yes, he agrees that there is a good reason why we should have it, but it just shouldn't apply to Rastafarian people. It's too overbroad. It doesn't allow an exemption for religious purposes. And that's what he bases his challenge to the Constitutional Court. And the Constitutional Court say that yes, this is an integral part of your right to religion. It allows him to connect to the higher spirits, as he says in the judgment, and therefore we do have a rights infringement on the right to religion, that he can't use it for religious purposes. And as you may know, the mere fact that we have a rights infringement isn't enough, and that's not the end of the question. We have to ask, can we justify it? So in looking at this justification of the rights infringement, the court basically said, like, how are we going to achieve this government purpose if we're going to allow the exemption to happen? How would we know if someone is Rastafarian? It's not written on anybody's forehead. It's not like you can pull out a card and say, hey, look, I'm part of the Rastafarian religion. It would become impossible for anyone to effectively police this issue. And for example, like if someone was in possession of weed, how would you know that possession is for religious purposes, or if it's just for some other purpose other than them saying I am a Rastafarian? It became impossible to police in that way. And also you also have to understand South Africa has an international obligation to curtail the war on drugs, as the court puts it. So it becomes a serious problem about policing and where South Africa stands internationally. And essentially what you have to understand is that the court agrees that there is such a severe rights infringement. It's integral part of his right to religion. And in order to justify having this rights infringement, the state has to show that there are no less restrictive ways to achieve that purpose. So like I said, we're already working on the premise that there is a legitimate government purpose in having a criminalization of marijuana. And the government basically says that we won't achieve this purpose if we allow this exemption for Rastafarians. And as I've explained to you, that is true. How would you police such a thing? So in order to achieve the government purpose, you need a general ban on marijuana. You can't make some sort of exemption that you can't then police later. And that's basically what the court finds. You cannot, we could justify the right to religion infringement because there are no less restrictive ways to achieve the government purpose, and in doing so, the Prince 1 case failed for those reasons. So fast forward almost 15 years later, and Mr. Gareth Prince, along with two other people, is in front of the Constitutional Court again, asking for their help. And this time they're coming from a slightly different angle. They're coming from the right to privacy instead of the right to religion. And to make a long story short, the Constitutional Court say they succeed, but only to the extent that you can use, possess and cultivate cannabis in a private space for your personal consumption, and that you are an adult. Okay, and that's what the court finds. But how does it come to that decision makes I think quite a difference to your understanding. Before I get into it, there is something I wanted to mention from the first Prince case, which is quite important in understanding this one. In the first Prince case, the court was split 5-4. In other words, there were 5 judges that said that we're not going to allow the exemption, and there were 4 judges that said that we should allow the exemption. And because it's 5-4, the 5 obviously won. But the 4 did mention something that's worth noting. They did say that there was medical evidence that proved that at a certain low level of consumption, there were no harmful effects of marijuana. And that didn't get quite a lot of attention because it's not quite what the court was dealing with at the time, but it becomes important in the right to privacy. Okay, so now the question is, what does the right to privacy mean? What does it entail? And a way you can think of it is how I think of it, at least, and maybe it makes sense for you, is you can think of it as a big circle, right? We've got a big circle, and a lot of stuff can go into there. Your sexual preference, your sexual orientation, your browser history, your financial status, your HIV status, your family, issues at home. All those things go into this big circle of privacy. And that would be a rights infringement. Now the question is, can we justify it? You can think of it as an inner core, an inviolable core. No public authority can stick their hands into this core and mess with these private issues. And the question of whether something falls into these private issues is, as I've explained, is a justification issue. So essentially what we've got here is that the court looks at this privacy thing, and they say that to the extent that the legislation doesn't allow an adult to use, possess, and cultivate marijuana for their personal consumption in a private space, that is a rights infringement. It does fall into the big circle, as I've explained. Another important aspect about this inviolable core that I've been trying to get across to you is that it shrinks, it expands and it shrinks. And that's according to how much you actually let out into the public. So let's say, for example, you are you're HIV positive and you tell people that you're HIV positive. And in doing so, you give it a public element, and you can't then rely on saying, oh, it was a private issue if you went out and you told people that you're HIV positive. It's almost like you can think of it like an inflated balloon, and everything inside the balloon is private, right? And the more you let out into the world, the more air you let out, the more it shrinks, right? And the less privacy you have over those issues. So what I'm saying is the right to privacy depends on how much and to what extent things are public. So back onto this justification issue, and the court now goes on to explain, are we going to justify it or not? And the court says that once again it agrees that there is a legitimate government purpose for this general ban or general criminalization of marijuana. Whether you agree with that or not, it's not quite the point. The court says that there is this purpose. The court also speaks about the harmful effects. It speaks about the psychology of it, the psychological effects, and the court also speaks about this gateway argument drug. And it's not necessarily a slight or a slander against the characteristics of weed itself. It's more about the proneness and affiliation to a drug subculture, and that should also be taken into account. Another thing the court mentions is that there is this international obligation that was also spoken about in the First Prince case, but the court also here goes a bit further and says that where the international obligation goes against our constitutional principles and what our constitution demands of us, then we don't have to blindly follow it. We can sort of deviate slightly so that we can stay in line with constitutional principles. The court goes further on to say that there are many democratic countries that have begun the process of either completely decriminalizing it or regulating it through legislation. And a sticky point that became in front of the court, as far as my analysis of it, is that the harmful effects of marijuana became something worth noting. There were contradictory evidence. There was a state witness, someone with a PhD and everything, who said that tobacco and alcohol certainly have harmful effects, but they're not as harmful as marijuana. And I know some people who would disagree with that, but that's what the state expert said. Then there was evidence by the World Health Organization that said, no, this is not true. There are very little and well documented, very little evidence that there are these harmful effects. So eventually the court sort of said, it looked at some of the evidence, and again it relied on the minority of the Prince 1 case, and it said that at this low level of consumption there are almost no harmful effects, and that evidence wasn't really challenged, it wasn't disputed. So if you think about it in that way, we can kill two birds with one stone. We can achieve this legitimate government purpose for this war on harmful drugs and things like that if we keep it at a low level of consumption. In that way, we're also speaking towards the right to privacy. So what I'm basically saying is that we can achieve the government purpose, and we can also allow people to smoke weed or use weed, not just smoke it, at a low level of consumption. In doing so, they can work harmoniously. One can exist at the same time with the other one. So here just to sum up what the court has said here, that no doubt, if we are going to not allow adults to use and possess and cultivate marijuana for their personal consumption in a private space, then we're certainly falling into the big circle of the privacy infringement. And once again, the question of whether it falls into this inviolable is something that you can't mess with. That's a question of justification. And once again, we're at this point that we were in the Prince 1 case. We're at the same point. We're saying, are there less restrictive ways to achieve the end? And remember, in the Prince 1 case, we couldn't regulate, we couldn't police this issue if we allow only Rastafarians to use it. It became a policing issue. So there were no less restrictive ways to achieve the government purpose. Here, it's slightly different. As I've explained, that we can still achieve the government purpose on potentially harmful drugs if we leave marijuana to be used at a low level of consumption. And that, when it's at a low level of consumption, it would fall into this privacy inviolable core, and therefore there is no way we can justify the right infringement. They have to let you do it. And that's very basically the reasoning of the court. Importantly, the court doesn't specifically say how much is a low level of consumption. It prefers to leave it at personal consumption. The underlying premise is that if you're going to use it personally just for yourself, there should be no reason that you're holding hordes and hordes of the stuff. It's only ever going to be a small amount. And I know some people are here saying to me, oh, well, personally, I use a lot of weed and I smoke a lot and I do this and I do that. And I think you're maybe perhaps missing the point. The court wants to regulate this without necessarily saying this is the exact amount that you should be using. And in order to say, to limit how much people are using, it says that you can only use it for personal consumption, which implies, what I'm telling you, it probably implies meaning it at a low level. So let me just sum up again why Prince 2 succeeds where Prince 1 fails. Prince 1 fails. They both Prince cases come to the conclusion that we have a severe rights infringement, and it's so high. In order to justify it, you need to be able to show that there are no less restrictive ways to achieve the government purpose for limiting the right in the first place. In the Prince 1 case, the right to religion, it became a policing issue. The police couldn't effectively say that we can achieve our government purpose whilst also allowing the exemption. Where it was different in Prince 2 is that we could still achieve the government purpose for criminalizing harmful drugs when in fact there is no harm at a low level of consumption. And that is why the court limited to the decriminalization of weed for the use, possession and cultivation of weed for personal consumption in a private space. And in doing so, the Prince 2 case succeeds. So now that I've explained to you how the court went through the Prince 1 judgment and the Prince 2 judgment, and eventually, after a long period of time, eventually it says that we are decriminalizing it to a certain extent. And what does that really mean for you? What can and what can't you do with marijuana in South Africa? So what you can do, firstly, what you can do is that as an adult, you can use it, you can possess it, and you can cultivate it in a private space for your own personal consumption. The court made a very defined, point in saying that we're not limiting it to a private dwelling. It's a private space. I mean, it's open to interpretation, but it would, in my opinion, it would certainly include possessing marijuana in a handbag or inside your pocket. Even if you're in a public space like a shopping mall or whatever, but you keep it in your pocket, then it's not an issue. It becomes an issue if you start taking it out and you start using it in a public space, because then, as I've explained, you're moving out of that inviolable core and you're allowing it some sort of public element, and that's certainly an offense. Another thing about marijuana is that it is limited to adults. In other words, you can't use it around children. And another thing is you can't use it around non-consenting adults. So for example, let's say you're at a braai or some sort of social gathering, and you decide that you're going to smoke weed or something like that, and you're under the assumption that it's a private a private event, you're going to smoke it there. But unless you've gotten consent from all the other adults there, then it's still an offense, and it's certainly an offense as well if there are children present. So yeah, the idea is to use it privately and not around anybody else. So in a private space, it's open to interpretation, but I would say that certainly, your home would be such a place, your pockets, your handbag, things like that. That's okay to keep it, and where you can use it depends on, is it a public place or not. The second thing is about cultivation. You can certainly cultivate it in a private space as well. What exactly is a private space is not clear either. It certainly extends to more than just your home. It's not saying that you can only do it in your home. You can certainly have it someplace else, but as long as it's in a private space, I'm not going to try to venture to say where else a private space is to cultivate it, but you get the picture. It's not only limited to cultivating it inside your home. And also on this cultivation issue, the court explains that dealing in weed, in other words, selling it and buying it, is certainly not allowed. That's definitely, the court can't endorse that kind of thinking. So if you want to stay on the right side of the law, you have to cultivate it for your own personal consumption, and you can't be going around buying it. I know there is a difference if it's for medical reasons, then the trader would have to have a certain license to sell it, but that's a different issue to what I'm talking about in terms of the right to privacy. Also on the cultivation issue, it's you can only cultivate it for personal consumption, which means that you can't have a forest of the stuff and then say it's for my personal consumption. And I know some people, like I said again, would think that a lot is for their own personal consumption, but it's probably going to amount to a criminal offense. Okay, so now the question is, what is a private space? What is personal? These are questions that the court doesn't answer. So in order to understand how we should work around this thing, is that you have to understand the court made a suspension for 24 months of its order of the Prince 2 judgment, suspended for 24 months. All right. In those 24 months, they gave Parliament the opportunity to amend legislation. In other words, to perhaps insert these words into legislation to allow this to a certain extent, that only that we can only be used in these circumstances, right? In these limited circumstances. And that was what? September 2018. We're now in February of 2020. So we've got like 8 months left for Parliament to do something. As far as I see it, they haven't yet done anything. And I don't know if they are going to. If Parliament don't do anything, then after 24 months, it'll kick in. So September 2020, and nothing yet has been done, then immediately the judgment becomes final, and what I've explained to you becomes law, and what is personal and what is private becomes a question of what does the court interpret it to really mean, and it would become an issue of interpretation. It would be a lot easier if Parliament just said, this is the amount that we're going to say is private, is personal, and this is the amount that we're going to, these are the circumstances that make it private. Okay, so in the meantime, I know it's quite unassuring that we don't know exactly what is private and we don't know what is personal, right? But I would give you to that is that there are some sort of guarantees or at least some safety measures in the structure of criminal law itself. The first thing is that the police officers have to have a reasonable suspicion that you are committing an offense in the first place. In other words, they have to come to a reasonable suspicion to say that you have an amount that is above this certain low level of consumption, that it's more than just personal, and in doing so then they would have to they can seize and arrest you for that, right? That's the first barrier, that the court have to have, that the police officer has to have a reasonable suspicion. The next level of protection is that in order to really be convicted, a prosecutor would have to prove, here we go, beyond a reasonable doubt that it wasn't for personal consumption, that you weren't using it in a private space. And what I'm saying to you is that if you are working in a gray area, you can certainly sprinkle some doubt over this issue, and there's a chance that you won't be convicted if you are in fact working in this gray area. So there are certainly cases where there is undoubtedly you're using this not for personal consumption. I mean, if you're walking around with kilograms of marijuana, you're going to be committing a criminal offense. Whereas if you've got a small blunt, one joint, then you almost certainly that's going to be for personal consumption. There's no issue there, right? It's everywhere. It's every space in between that's slightly gray, and we don't quite know what's going on. And as I've explained, there's enough defenses and safeguards in the structure of criminal law on its own to safeguard you in the time being. But like I said, there isn't quite consensus of what these things are. So my best advice to you, in order to stay out of trouble, is to please be conservative. Be conservative in the amount you carry with you. Be conservative in the amount you use and the amount that you cultivate in private spaces. Make sure that these are private spaces, right? And in doing so, you'll still stay out of trouble, and hopefully we'll get more clarity on this from Parliament one day or through the courts in due course. But yeah, guys, that is the status of weed in South Africa. I hope you learned something from this video. And like I always tell you, that the law is only a tool, whether that's for good or bad. Its real usefulness depends on those who understand it and are prepared to know more about it. Because like I always say, knowledge changes everything. Cheers for now, guys.